First, before starting this topic on intellectual property rights, just have an idea what do you mean by intellectual property rights. So if that concept, if your concepts on intellectual property rights is clear, then we will able to distinguish between the different types of IPRs. Okay. Now, if you go back to our first session of Indian economy, we already discussed very important point. Okay. We can understand the concept from the term itself, right? So what is this IPR? Intellectual property. Intellectual property rights. Now what do you mean by rights? What do you mean by rights? Do you enjoy any rights? Yes, you enjoy certain rights. You enjoy certain legal rights. You enjoy certain fundamental rights as the citizen of the country. So rights means it is you have certain right, but here the right is not legal right or fundamental right. Rather, the right is to the intellectual property. Okay. So what do you mean by intellectual property? See, you know that what is property? Land is a property. Huh? Any asset you are having is a property. But this is again it's added by the word intellectual. So it is a property which is creation of intellectual thing or mind. So you are creating something out of your mind. Okay, so intellectual property is nothing but your creation of your mind. Okay, you see any scientist, he is inventing something. Invention is creation of his mind. You see that a novelist writing a novel, that is also what his creation of a mind. This what is Bahubali's director name? Oh, very good. UPSC will not ask. Okay, so Rajamouli have directed a movie called Bahubali, and the movie Bahubali is his, that story or the direction, everything is his creation of his mind. Okay, and he has executed it. So anything which your mind creates is what it is. It is nothing but intellectual property. Okay, so since you have created something, out of your mind, and for that you have taken lot of time. Okay, you know how many years it has taken to make Bahubali? Then you will understand. Okay, because Bahubali means everybody will understand. It's not only about Bahubali, that any other thing. Now think about anything. Means the first time a person who invented a mobile phone or any technology, he has invested a lot of his time for that creation. Okay, a person. So because of his effort and intellectual have given to create something, certain right, because of the effort he have put, the time, the money, everything he has spent on this intellectual property, he should or he have the right to enjoy certain rights. That rights is what is called as intellectual property rights. So intellectual property rights means the rights given to the intellectual property owner. Rights given to the intellectual property owner, or the creation means the rights given to for something for your creation of your mind. That is what is called as intellectual property rights. Intellectual property rights, it's a very simple definition. Okay, so be very clear, it should be a creation of your mind, then only we can call it as an intellectual property. For that, if the government is giving you certain rights, that right is what is called as intellectual property rights. That's the basic definition of IPR or intellectual property rights. Now try to understand that there are different types of intellectual property rights. So we can categorize intellectual property rights into two categories. We can categorize into two. One is copyright. You might have heard the word, okay, copyright, okay, copyright, and we always violate this right by photocopying the standard textbook. Okay, so anyway, copyright, and this word is very important, copyright and related rights. This is one classification, copyright and related rights. Now Keep this in mind, okay? Where you are studying copyright and related rights? Under IPR, under intellectual property. So copyright is also a intellectual property. Means copyright means you are creating from your mind certain things. Okay, so we'll see that for what work, for what creation of your mind you get copyright. That is, this word is very important for any literary and artistic work. For any literary and artistic work, any literary or artistic work, that intellectual property right which you will be enjoying is what is called as copyright. So literary works like if you are writing a novel, artistic work like your drawings, paintings, all will come under artistic work. So any literary and artistic work will be, so if you are writing a new book, whether not only in any book, okay, if you are writing a book on civil services which nobody have written, which you have not copied, if you copied it, it's not creation of you, but somebody else, so that's a violation. Okay, so any literary and artistic work, and it is your creation, your mind creation, then you can protect under intellectual property. Okay, now there are related rights, so something related to copyright. Related rights are like rights like, okay, even under this copyright, even it includes, okay, this performance rights are there. So first we'll just have an idea. This first we'll copyright for what? Copyright is only for literary and artistic work. Now what is this related rights? Related rights is mainly one is broadcasting organization. Broadcasting organization. You might have seen that, okay, BCCI sell this broadcasting rights to certain channels. Now once they get that broadcasting rights, now nobody can't violate it. So for that BCCI earns crores of money. So broadcasting rights, it's not directly a copyright, but rather it is a related rights, or you can say the neighborhood rights of copyright. Then people like Rasool Pukuti, you know, na, Oscar, means what do you do? Sound recording. So the not for Rasool, who is the producer of phonogram or sound recordings? Phonogram, producers of phonogram, they will come under this related rights. One more is there in relation to performers. Rights of performers like singers, then actors will come under this performers category. They all perform, they are performing something, and for that they can say that, okay, they can ask for this related rights. Okay, so but you can say that, okay, it is somewhere, we can classify this category into copyright and related rights. So what is important for you is copyright, and the key word for copyright is literary and artistic work. Okay, so copyright is a very important intellectual property rights. Now when you from your prelims point of view, okay, from your prelims point of view, what UPSC may ask is that, okay, you need to know the basic definition of copyright. Now I told you how UPSC, when they want to manipulate a statement about copyright, what they will do? They will take the features of some other intellectual property right. So once you know that copyright definition is this, be very clear with it. Now regarding this copyright, okay, see, I told you they enjoy certain rights, yes or no? Those who are the owner of intellectual property, they enjoy certain rights. That rights is main rights is economic rights. Main rights is economic rights, in the sense that for a certain period of time, okay, they will be, if they are producing that thing, or if somebody want to use that, he need to pay him. Okay, for example, I am a book publisher, means I am a publisher. Okay, I am only a publisher, the author is someone else. So as a publisher, I need to give this royalty to the creator. So as the number of printing, means the number of copies increases, the owner, the creator will get the benefit. So that's his economic rights, because he has created, this publisher is what he was doing, is simply printing the copy only. Okay, so like mainly this every intellectual property rights, the major right is there is that he enjoy for a certain period of time certain economic rights. Okay, so mainly monetary in nature. Now, so in relation to copy, then regarding this, they will ask you, okay, normally the time period of intellectual property rights. So to four means time period means till how many years they can enjoy this intellectual property. I will tell you that every right has a particular tenure, but for you only you need to know only about one intellectual property time period. Rest of the time period of any intellectual property rights is not important for you, and don't waste your time also, but just go through it. That is in relation to patent, which we will be discussing. That's a very important. Patent, what is the time period for this? What is patent? We will discuss. Okay, so rest of the thing, even though it's given in the material, just go through it. Don't give too much of importance to that factual information, that how long. For example, it says that the copyright owner will enjoy this right, copyright owner will enjoy this right 50 years after his death. So in his living time he will enjoy, even after his death he can enjoy this right even after 50 years. So it's not that important for you. Okay, so UPSC will not ask what is the time period for a copyright owner. What UPSC will ask is, what is copyright and what are the benefits they will enjoy. Okay, so main benefit is that, okay, one thing about this copyright is that there is a concept what is called as, in relation to IPR, there is a concept what is called as licensing. This is a very, very, very important concept in relation to intellectual property. There is a concept what is called as licensing. Licensing means now I am the creator of something. So creator means I have some intellectual property. Now the problem with me is that, okay, I can't market this product all over the world. I can do it in one country or two country. So what I will do is that, okay, because I know that this my innovation or my creation can make money. So what I will do is I will give someone else. I will give, for example, take this case of a product. I have created a product, and in India I have the intellectual property rights, but in US I don't have the proper setup. What I will do is that I will license this right to someone else, so that he can produce that product in US and he can sell it and he can make profit, but in return he will pay me some money. So licensing is, you are giving the right, you are giving your right to produce and sell to someone else. So it's in relation to copyright also, licensing has to be done. So that actually, so once you give this licensing right to someone else, what you need to, there is an agreement between them. As per the agreement, it have to follow. Now what is this licensing is that, so be very clear. Licensing means the intellectual property owner will give certain rights to someone else in return for something, mainly in relation to money for a certain period. So this is a very important right enjoyed by the intellectual property owner. So first thing is that if he want to produce and market it, he can do it. If he can't do it, he can ask someone else to do it and he will enjoy benefit out of it. So this licensing is allowed. It's a very important right, licensing right is being given to all the intellectual property owner, But there is a difference. We'll discuss when we discuss. So make sure that, so copyright can be given to someone, can be licensed if he wishes to. But normally in relation to copyright, what he does is that, okay, he will ask somebody else, for example, the producer of a movie. He will give this right, means he will sell that right to some other, for example, after a certain period of time, it will be given, the satellite rights is there. So like that, he makes money not only by in relation to this movie collection, but there are different way in which they make money. One is that giving a certain right. For example, satellite rights means if I give it to a channel, then the channel will pay him the money. Okay, so all these are enjoyed because he is the creator. He is the creator of creation of his mind, because it is an intellectual property. So one category is very simple, copyright and related rights. So they will ask you, they can ask you like this, what all constitute this related rights under copyright? These are the three, it's there in the material. Or for what this copyright will be given? It is to literary and artistic work. The second classification under intellectual property right is second classification, industrial property. This word is very important, okay? It's again a intellectual property. Yes or no? It's an intellectual property, but this property will be having some industrial application. Will be having some industrial application. That's why it is called as. So, see, this is not any textbook standard. It's for you to understand, and for you to answer any question on intellectual property rights. It's not, there is no classification like this, but only for you to understand the concept. So under industrial property, we can classify into two categories. Means again under industrial, we can classify into two categories. One category is under industrial, it will protect. So under this means it can protect a certain distinctive sign. Protection is for distinctive sign. Protection is for distinctive sign. This word is very important. Okay. Protection is not for the product, but for a sign. What is that sign? It is a distinctive sign. So under industrial property, we can classify into two. One is here the protection will be given to, as we under IPR, the protection will be given for a distinctive sign. Okay, I'll give you. Okay, one example of distinctive sign is what is called as trademark. So trademark is a intellectual property. It's an intellectual property. It's an intellectual property rights. It's an intellectual property rights. So who enjoy? So what? Have you seen any trademark? You look into if you are having watch, you see it. If you have any shirt, you see it. You wearing shoe, you see it. Everything will be any branded item. Any branded item will be having a trademark. Any branded item will be. For example, you could see that, okay, Nike sign, Nike shoe. Okay, Titan have a brand. Every product has a brand. Every product has a brand. Now, so what this trademark says that, okay, you've seen that, well, it's better you will understand that in relation to car. Benz have a sign. Okay, can you imagine that? Okay, Innova has Toyota have a sign. Then any car you see, everyone will be having. Now, what does this sign signify? Sign signify means, now if you see this sign of Benz will be having different products. Means Benz will be having different. You think only Benz is creating only one type of car? You know it, no? No, there are different. But for everyone they will have a common sign. Shows that this car is from Benz, so that the customer is aware of. Okay, so this right is being given, this trademark right is being given to a manufacturer or a service provider to distinguish his product, from others, so that the consumer is clear cut that, okay, I believe in this manufacturer, I believe in this particular company because his product. I hear that, okay, there are certain people, okay, even my father used to say that, okay, Toyota brand is very good because Toyota car have certain features. If it is a Toyota car, even a new car, you don't aware about it's a new car, but you know that it's Toyota is introducing a new car, Innova, new form, whatever it is. You have a belief that, okay, if it is Toyota, then it is, means you can purchase it. What is that? It's having less maintenance work. That's the quality of. Now, how you will able to identify it? Okay, how you distinguish means how you able to identify it through its trademark. That it's confirmed. It is nobody else can use it. If somebody else use the trademark of Toyota, then Toyota will sue them. It's violation of intellectual property rights. So trademark is an intellectual property coming under industrial property. In which classification? Here the protection is not for anything, just for that distinctive sign, So trademark, under trademark, that distinctive sign is protected, so that it will ensure fair competition. Every company or any producer who want, he can show that this is his product. Nobody will use that product. Okay. And second thing is another category. Okay. So one category under protective to protect distinct sign is trademark. So this trademark is an intellectual property. So that's why you use the word TM. You can see that trademark. Okay. Second is what is called as GI. Geographical indications. Again, under geographical indications, the protection is being given to that distinctive sign only. So under this category, protecting distinct signs, there are two are there. That is trademark and geographical indications. GI, geographical indications. Now just I tried to, what is GI? It's an intellectual property. Now what is the specialty of this GI? Just what is GI? Geographical indication. So this shows that a geographical indication is given to a product. Geographical trademark can be given both to goods and services. But GI, geographical indication, can be only be given to a product. Why is that? Because it says that, okay, this particular product have originated. You know that when you study geography, you know that because see, do you think that the geography of every part of the world is same? It's different. Okay, if you take Kerala itself, in Kerala there are like like if you see this coastal area or the hill, if you go to Munnar or if you go to Wayanad, all will have a different geographical, and because of the geography it has certain features, and the product over there have, because of it is originated in that particular geographical region, it has certain unique features. For example, tea from Darjeeling tea. What do you mean by Darjeeling tea? Tea which is seen in the Darjeeling area. Now Darjeeling was in news because of this Gorkha land agitation and other things. Similarity is there, and if you go to Munnar also you can see their tea estates. Can you call the Munnar tea this Darjeeling tea? No, because it's not. So you can call that by Munnar tea because it's from Munnar. But what I am trying to say is, geographical indication means it is basically an intellectual property where it is protecting, this protection is being given to distinctive sign, and normally that distinct sign is the name of the place itself. So you can identify GI by saying that it will be saying, normally the majority of the cases, I am not saying every, if you take many geographical indications, it is indicating a product and it says that where it has originated. It is, so every geographical, if you look into different, for example, you hear about the place called Tirupati, very famous temple. Tirupati, you know the specialty of Tirupati Laddu. Okay, so now Laddu, you will get here also, if you go to any bakery you will get Laddu. Nobody can't sell here. Now see, basically this Tirupati Laddu, the way they produce it also have some other, what is that unique feature? Because it is associated with the temple, some belief is there. So we believe that okay, it has its composition, whatever it is, and so that Laddu can't be, somebody else can't say that okay, if somebody is producing something in Kerala and saying that this is Tirupati Laddu and selling it, then Tirupati people will come here and beat him. because it's their right, not the people over here. You sell it by saying that, okay, this is Trivandrum Laddu or something like that. Nobody will complain. If you can get geographical indication status, that it's not a normal thing. You need to apply for it, and you have to prove that it is only seen in this region, and it has certain, because of this, it's seen in this, it has certain unique features. Now try to understand that this geographical indication is not only for this food stuff. It includes agricultural products, it includes manufactured products, it includes handicrafts. You hear about Scotch, whiskey and all these things. You know what is the specialty of this? That, you know, wine or drinks, okay, but it is associated with the place. Okay, it's associated with the place only. So geographical indication, it is being given to a product. That product can be manufactured product or industrial product. It can be agricultural product. It can be food stuff. It can be wines or drinks, whatever it is. But the important criteria is, the important product criteria, it is given only to product, and this distinctive sign is given to identify that product have originated in that particular region. For example, okay, now you might have heard about basmati rice. Basmati rice is a geographical indication. Okay, so basmati is not a place name. So basmati is to show that, okay, this rice has certain unique features, and this basmati rice is grown in certain part of the country. Okay, in a particular region. So only in that, since this rice is grown in that particular region, this rice has certain unique features. So recently what happened is that, okay, so in the regions like Punjab, Haryana, and now when you hear the word Punjab, there were, before partition there were Punjab word too. Punjab is there in Pakistan also, so that's a different thing. I am not going to that part. So some farmers from Madhya Pradesh claimed GI status for basmati grown in Madhya Pradesh, but the this geographical indication registry didn't approve it, because it is not showing that geographical region. Then under geography you will see that, okay, what is the region in which this basmati is grown. Okay, but many of the cases this GI is, you can identify with the name itself. Vaichurkau. Then if any pineapple is in Kerala, it's a very famous Vaikulam pineapple is there. It's all associated with the particular place, it has been grown in a particular region. In Kerala itself, then there are from, if anybody is from Alleppey, you have anyone from Alleppey? No one, huh? So you have one handicraft is there, choir, so many are there. A list of thing is there. The handicrafts from Alleppey is very famous, and it's got this GI tag. Okay, now why I am saying is that now the important from GI is that 2 times UPSC asked question from GI. One is in relation to the concept. One is in relation to the concept. Okay, now when I said concept, I am giving you a prior warning. Your 2018 prelims, from economy point of view, there is a high possibility that UPSC will go back to 2012-13 year questions. 12-13 year question. You know what is the specialty of 2012 and 13? UPSC asked concepts, more concept question, less current affair. Now don't blame UPSC if UPSC is asking more concept question in 2018. Our approach is, we'll study both. We'll study both concepts, thorough, as well as why is that, how I am able to know that, because UPSC have shown me an indication. What is that? Today was economy mains question paper. All the questions were conventional. Almost all the economic questions were conventional, that too from the syllabus. From this, see, it's not outside the syllabus, from the syllabus itself, what is mentioned in the syllabus. So it is giving an indication. So there is it's only a possibility, but just telling that since UPSC have given indication, anyway we'll see, our strategy is very simple. First we'll study concepts, then only we'll go to current affair. In economy there is a problem is that without understanding the concept, you can't understand the current affair also. Anyway, just note down this 2012-13 questions, okay. So it's basically a conceptual related question. Now in relation to this GI and trademark, both are industrial property, and what is common for trademark and GI? The protection is for the distinctive sign. So you can produce the same product anywhere, but you can produce, but you can't use that sign. You get in the point? If I was there in Tirupati for 10 years and I know the composition of how to make Tirupati laddu, I can come here and make that laddu, and I can sell it. If somebody likes my laddu, it will sell like you all will come and eat. But the problem is that I can't use that word what? Tirupati. I can only use the word laddu. I can write the word some tea laddu or something like that. I can write to show that, okay, see here I was there and I was a native of Tirupati and I know it. I'm producing it here. So if you want same laddu only, you will get there also. Okay, then people will not buy it. Yeah, Tirupati, it's something different. Okay, anyway, I'm not going to go into that part. What I'm trying to say is that this is the key thing. The protection is only to the distinctive sign. Protection, so that the consumer will aware of, okay, this product is from this geographical origin, or this, because since it is from this geographical origin, okay, it has certain unique features. Now in relation to licensing, this is a very important thing, okay, in relation to licensing. Now this trademark is a right of a company, or it can be an individual also. So, okay, an individual or a company can have this trademark right, okay, for his product or for his services. But what about this geographical indication? Is it the right of an individual or a company? No. Geographical indication, this right is for whom? The people in that geographical region. That is, GI is not an individual right, rather GI is a community right. I told you this Darjeeling tea. The people, so anyone in Darjeeling can use the word Darjeeling tea, provided it is following certain norms. Provided that certain norms is being followed by them. Okay, so any people in the Darjeeling region, the tea which is produced over there, they can use the word Darjeeling tea. Similarly, the people living in the Tirupati area, near means the Tirupati region, if it is following that unique qualities of Tirupati laddu has a particular size, certain form is there. If they are following that, they can use the word. It's not, that laddu is not only for the temple, for that region, Tirupati region. So that right is for, it's a community right. Now it is a community right. Can you, so since trademark is a company or individual right, can he go for licensing? I am talking about trademark. Trademark can be licensed. That's why how this franchise concept have come. Franchise, you might have heard about franchise. You heard about this institution called time. Do you think that every time owner is the same? No. What is the common thing is about is that the trade, this thing will be there, time, everything will be time. The notes will be the same, but the people who teach and the management will be different. They'll give, so they if they want, the real owner can give it. So trademark can be licensed. Trademark can be licensed, means you can give someone else to use your right and you will get payment for it based on that agreement. That's internal, it's personal. But what about GI? So basically this GI, this right is being given to that particular people in that region or to that community. Can this right be licensed to someone other, means outside that region? No. Why? If it has been given to, then it will lose that geographical status here. See, GI is being given to a particular geographical region only. Now it can't be licensed outside any part of the world or any part of the country. So this is a very important point to note down regarding trademark, and it was a UPSC question also. It was a UPSC question that trademark can be licensed. So you need to know the meaning of licensing. The meaning of licensing is that the right to sell or to create or to modify your own creation or your product. So this licensing is allowed under trademark because it is your own right, okay? It's your property. It's your wish to give license or not to give license. But this GI is, since it belongs to a community or since it belongs to a particular region, this right can't be, means this licensing can't be done. Because that features belongs to that particular region only. Okay, so these things, be very clear about this trademark and GI. Both are trademark. Under both, protection is being given to the distinctive sign. Trademark, the honor it can be for goods or services, but for GI it is only for products, goods only. And you need to understand what all goods are being there. It's there in the material. Under trademark, licensing is allowed. Under GI, don't by heart it, understand it, okay? Understand it, why it is allowed, why it is not allowed. So this is one classification, okay, that under industrial property, you're protecting distinctive sign. I told you, UPSC normally, if you, out of our whole module, from the prelims point of view, this is the chapter where UPSC have asked less questions, but if you see the trend, the last in the last 3 years, that's in UPSC asked question in 2017 also, UPSC have asked the question in 2015 also, then it went back to 2010. Okay, so this area is very important for reason being many in now intellectual property is a very important current affair. And once this government came into power, they are doing many things in relation to this intellectual properties in India. Now we will see that, okay, see that question number 2. Now see, keep this in mind. Don't study all the fact. Don't study all the fact related GI, because there are hundreds of GIs in India. They will not ask GIs outside the country. So if there are a lot of GIs are there, mugging up all the GIs is not, it's a foolishness. What you need to know is that every year this GI registry, what is GI registry? It is the government organization which gives GI status to any product. GI registry every year normally they give GI status to 4 to 5 or 6 or maybe till 10 they will give. So what you need to do is that you need to identify, okay, in 2016 or in 2017 or in your 2018 means till March, how means which all product got GI status, GI tag, not status, GI tag. That you note down, that is one important thing. Second is that any GI which is in news, any GI, it's a current affair. Okay, so in relation to this question, okay, this Rajasthani dal, it's a food product, okay. Rajasthani dal bati churma was in news, not in relation to GI. There was a proposal to give a GI tag at that period of time. A proposal only, and it was in news for few days. And still now it has not got GI tag. So if anything like that comes, you just need to note down. Sometimes when in the newspaper they'll see that, okay, today some product have got GI status, GI registry have given that GI tag. Then there will be some, so what will have, two things will become important for you. Which product got GI tag and what is the feature of that GI tag, means that product, because it has become a current affair. You have to go in depth about that product, nothing else, what is mentioned in the newspaper. So since you have lot of time, since GI is a favorite area of UPSC, any news on GI is very important. Okay, so one question can be, they will ask you, okay, which of the following have been given GI tag in India? So instead of studying all the GI, you will get, it's like studying all the wildlife sanctuaries. Then finally you will not answer any question because full confusion. Either whether it is a wildlife sanctuary or it's a tiger reserve or something else, any other protected area. Again, UPSC will ask only those wildlife sanctuary which are in news in the last 1 or 2 years, or a very important wildlife sanctuary, in the sense that very important. How will you be able to know? Look into the previous year question. You take your this protected area material and see the last page. Previous year question, then you understand. So all these wildlife sanctuary have been asked by UPSC. These are all UPSC favorite wildlife sanctuary. You revise it, and any wildlife sanctuary which is in news, like that. Okay, so like that GI you study it. Okay, this question show you how UPSC have asked question earlier. So how you have to prepare in relation to GI. So here in this question, Banaras saris. Okay, you know that. Okay, Banaras saris means every woman. Even you don't know where is Banaras, but you know about. Okay, Banaras saris are very famous. Okay, it has certain features. Okay, and because of that, it's very costly also. So anything which get GI tag, try to understand that it is costly. So Banaras saris and Tirupati laddu both are having GI tag, not for Rajasthani dal bati churma. So answer is 1 and 3. Just have an idea. But this third question you answer it. Okay, now you know the concept. You try to answer it. 3 statement question. So apply elimination method and answer it. So first statement is correct. So you will eliminate what? You will eliminate C. Second statement. Second statement is also correct. So you can eliminate A. What about third statement? Why? First of all, UPSC have given you a chance here. I had given you an indication. I have manipulated the statement. What is that manipulation? What is that manipulation? What UPSC have done here? Only. So be very careful. Okay. Only is, then when you see all and only, you have to read 2 or 3 times and to confirm it. Okay. So trademark is assigned to the manufactured goods, whereas the GI is assigned to agricultural goods and products and handicrafts only. Is it so? No. It has been given to industrial goods also. It is given to food stuff also. It has been given to wines also. So that is a wrong statement. That is a wrong statement. Okay. So answer will be B, 1 and 2 only. Okay. So like that UPSC asked this question. So be very clear the area. Okay. Now try to understand that this IPR, again, if you look into your WTO website, in WTO website there is a thing called TRIPS agreement. There, actually this statement UPSC have taken from that WTO TRIPS agreement website, and it's there in your material. Now don't go to WTO website, it is there in front of you. What WTO website is there in your hand. In the UPSC source here, so there is you need to read that only. So there it is. If you see that page number, page number 9, that's showing like there is a heading called difference between GI and TM. Write it important, because from there only UPSC have asked this question. UPSC can ask that from the similar area. Okay, so this is, so till now we have studied 3 important intellectual property. What are that? Copyright and related rights, then trademark and GI. Now I told you there is another category under industrial property. Another category under industrial property. That is basically for, so under industrial property, another category is, so here in this, the protection is for protecting distinctive sign, protecting distinctive sign, protecting distinctive sign. Now the second category is, the protection is basically for, it can be for your invention or your innovation. You are innovating something. To stimulate innovation, some protection. For you to stimulate innovation or to create, to find something new which have never been there earlier, or some techniques which can solve certain problems. So basically, this other category includes certain inventions or certain designs, etc. So under this category, this invention category, under this invention category comes the most important IPR, what is called as patent. The most important IPR is patent. Most important IPR is patent. So patent is an intellectual property right. Now for what patent will be given? If you invent something, if you invent a new product, if you invent a new process, you can apply for a patent. You can apply for a patent. Now I told you yesterday, as part of this TRIPS agreement, every member country have, especially for drugs and certain foodstuffs, have to shift from process patent to product patent. Okay, so now for us, what is important here is, in relation to, first try to understand that patent is being given for the intellectual property owner for the creation or for inventing something. And the I told you, in relation to any other intellectual property, the time period is not important. But for patent, you need to know that, okay, so if you are a patent holder, what does it mean? You have invented something and you enjoy certain exclusive rights for a certain period. You enjoy certain exclusive rights for a certain period, and that period is 20 years. It's a fact, but very, very, very important fact. Always keep in mind. The patent holder can enjoy this right only for 20 years. It's a very, very important information I'm going to give you. So after 20 years, what will happen to the right holder of that patent? He will lose all the rights. Get to the point? So after 20 years, we call that invention or that product as off patent. What is it? Off patent. Means the patented, now after the 20 years, anybody can produce that product. Nobody will stop you, because the patent holder loses his rights. He enjoyed rights only for 20 years. Okay. Now I will give you an example of this India's case. So the drug companies, so they will enjoy patent for their drug because they have invented that drug. And what is the specialty of that invention? They can treat a particular disease, mainly a disease which there was no cure to it, especially in relation to cancer drugs. Now here, the interesting thing is that this pharmaceutical companies, after 20 years, they can't now, means they lose their patent right. So after 20 years, any other company can produce the same drug. You get the point? So every branded, you can see that many. Tell me one very important brand, Cipla, na? Cipla is a drug. Cipla, then tell me few, na? If a multinational company, Ranbaxy is Indian, but now it is taken over by. There are so many multinational companies are there. What I am trying to say, now try to understand that after 20 years, now anybody can produce the same drug. Now after 20 years, so in this 20 years, the drug will be called as patented drug. After 20 years, they will be called as generic drugs. Keep this in mind. So once a drug loses the patented status, okay, now my company is having that patent. So I enjoyed this patent for 20 years. It means that during this 20 years, no company can produce my drug because I am the patent holder. I am the person who find this product for the first time. Now it is product patent. Now we are in the TRIPS agreement. What TRIPS agreement says that Now there is only product patent. So my company find this for the first time. We invented that product, drug, for the first time. Now nobody else can. Now you can't use any other process to produce the same drug, because now it is not process patent. Now it is product patent. Now if some other company want to produce the same drug, they have to wait for 20 years to complete. Now after 20 years, any company can produce that same drug. So if any other companies produce the same drug, those drugs are called as generic drugs. So what is the specialty of generic drugs? They are off patent drugs. Now what is the specialty? So what is it in relation to price? Which one will be expensive? Patented drugs will be expensive, generic drugs will be very cheaper. So 4 or 5 companies will produce the same thing at a lesser rate. So which is good for a country like India, poor country like India? Now if you say, we have a lot of Indian companies which produces generic drugs, and we are known as the pharmacy of the poor world. Why? India is known as the pharmacy of the poor world? Because we produce generic drugs and export it. We give it for our country people and also for the poor countries like Africa and other areas, because we have that expertise. We have a very strong pharmaceutical company base in India. Okay. Now, very interesting thing regarding this. See, when we talk about patent in India, the majority of the issue is associated with this drug. But if you go to US, there are many techniques and technologies are been involved. But for us, we are more concerned about drugs because we are a poor country where health infrastructure is very poor. The health indicators are very low. It's below even we can compare our health indicators to sub-Saharan region. I'm not going to that part. So in that scenario, the drug companies, especially the Indian generic companies, producing this drug is very vital for our health support system, public health infrastructure. Now, so I'm not going to that because almost 90% of the current affair related with patent is associated with drugs only. Okay, now try to understand that. Now you think that, okay, a patented company, what normally they use the trick, they use a very simple trick. Now I'll tell you that how this and some other producer can produce this patented drug is that after this 20 years is that there is a rule. When you apply for a patent, okay, when you apply for a patent, now try to understand, patent are territorial rights. Patent are, so these two important points. Okay, one is that the time period of patent has been given for invention. Patent is given for invention. Second is patent is given for invention. Second is in relation to patent are territorial rights. Patent are territorial rights. What do you mean by territorial rights? If you get patent in India, if a company wants patent in India, it have to apply to India. Then the Indian Patent Office have to give them the right. So if a patented company is saying that, okay, I have patent in US, so that I need patent in India also, it's not possible, because US is a different territory, India is a different territory. You might have got patent from in US, but if you want to get patent in India, you need approval from the Indian Patent Office. So that's what you mean by territorial rights. Means patent you will get only in one territory, one country. Okay, if you get, see, if a company have got patent right in one country, it doesn't mean that he will get the patent right in other country also. He have to apply for, he have to give the information and have to apply for it. So that's why many of the multinational companies who apply for patent in India have already got patent in their respective country. Now India follow a strict patent regime. India follow a strict patent regime. Why? Very simple, we are still a poor country. We are still a poor country. Okay, and we can't afford costly drugs. So because of that we follow it, we are forever. But in relation to developed world, they have, see, in their, many of the, for their citizen, you know that Obamacare, what do you say Obamacare? Everything is free. Okay, that is not possible in India. So this be very clear. Okay, it's a patent is a territory. You need to understand the meaning of it. What do you mean by territorial rights? That right is only for, but not in the case of copyright. But for patent, it is a. So be very clear. It's a territorial right, and you need to apply for it. Okay, and that particular territory is very important. Second thing regarding this patent is that you have to disclose your invention. You have to disclose your invention to the patent office. So if you want to get patent, what you need to do is that you have to disclose the information to the patent office, and what the patent office will do is that it will put this information into the public domain. You get to the point? Already the invention will be available to the, after a certain period of time, this invention will be available to the public, because patent office, and they will ask, or if there is any opposition is there for this, I am going to give patent for this invention. Do you have any opposition? That is what is called as pre-grant opposition. Pre-grant opposition means before granting patent, if you have any opposition, that is what is called as pre-grant opposition. Now after giving patent, some company will come and tell, this was my creation only, this person have misused it, and I have the proof that I have invented it, and I already all the information. That is what is called as post-grant opposition. Means after granting patent, some people will get to know, hey, yeah, you don't know, you might have seen that in relation to many movies. It's not patent, movies means it come under copyright. Yeah, your story is now playing a movie. This many allegations I've heard about it, because this fellow have already told the story to a director. That time he said, yeah, it's a bekar story, you go. But he made it, means he had taken 80% of it and he made a movie out of it. Okay, but he was not knowing it. This movie have been made and it was his story. But so that's like what do you mean by this post-grant opposition? So in relation to patent, so since this information is available in the public domain, this patent information is available in the public domain after 20 years. So already the company is ready to produce it, because they know everything. Only thing is that they require that 20 years to get over. Then only they can produce it. Okay, now what this especially these multinational companies will do, these people are very greedy. Have you seen this movie called Thani Oruvan? Yes, Thani Oruvan. Hey, movies are knowledge, good movies are good knowledge for UPSC aspirants. This Thani Oruvan, what is his name? I know that villain name, this Arvind Swamy. What is his? Jayan Ravi. Jayan Ravi is not important. This fellow is important. Arvind Swamy is important. Why? Arvind Swamy is the villain here. Arvind Swamy, he is violating. What is? See, basically, he is controlling the entire pharmaceutical companies in India. Okay. Now, normally what these multinational companies will do is that, okay, so when foreigner is coming to India, now she has an intention to sell a particular product at a lesser price, that will affect the multinational company also. Okay. Now what I am trying to generally, so that type of foreigner you will see only very rarely. That's only you can say it in movie only. So multinational companies, normally what they does is that they are not happy with this 20-year profit they have made. They want this patent to continue even after 20 years also. So the patent is for 20 years. So what they will do a trick. What the trick this multinational company will do, they will in the 17th and 18th year, they will spend money for a research team. They will send a team, and they will find that now that medicine is not working here. This medicine is not working like where it used to work. So they will come up with a report that this medicine have lost its therapeutic efficiency. So now we are going to invest again, and we are going to come with a new product called 500 or 700. Earlier it was 500, now we are coming with 800. Something they will say, and they will change the name of that product. And by saying that, now we are going to again set up a research team, and we are going to increase its efficiency, therapeutic efficiency. And what they will do after 20 years? they will again apply this. They will tell them, okay, this is the new invention. We are now created a new product which is much better than the earlier medicine. Please accept our application and give us 20 more years this right. This is what is called as evergreening of patent. It's a very important term. Evergreening of patent. Evergreening means after 20 years again they will come with the same trick. Then this product will always be patented. It will never become a generic drug. For that, Indian patent law have a very important clause. This is very, very, very. So to prevent evergreening of patent, Indian patent law have a very stringent section. Indian patent law are very, very important. This is very, very, very important for you. It's a very important clause, what is called as Section 3D of Section 3 Clause D of Indian patent law. What is the aim of this Section 3D? To prevent evergreening of patent. Now this Section 3D says that if any drug, if they want to extend its patent period, they have to prove that the efficiency, that this word is being used under Section 3D, what is called as enhance. If you want to continue the patent, you need to prove that you have enhanced the efficiency of that particular product or that particular medicine. So many drug companies will say that, okay, a new form have been used, new substance have been used, so that now this is because of this new form and new product, we have improved the efficiency. So in many cases, Indian Patent Office have rejected it. Okay, this product is not having this enhanced efficiency. And then one multinational company called, it's there in the material, called Glivec. It was a UPSC mains question also. A multinational company called Novartis have applied for, the drug name is, it's a cancer drug called Glivec. They applied for this patent continuation, and they saying that, okay, this Glivec have this enhanced efficiency. That time Supreme Court in this case, Glivec or in this Novartis case, have said that, so this is the interpretation of Supreme Court. The enhanced efficiency here means therapeutic efficiency. Means you have to prove that this new product or new drug have therapeutic, means in the therapy, means in the treatment, means it's bringing an efficiency in the treatment. Then only the patent office will give you extended patent. Based on this therapeutic efficiency definition, Supreme Court have rejected the application of Novartis and became a very important judgment in India's patent history law. And that year itself UPSC asked a mains question. That's why in this 2013 question, if you see the third question of mains, it's there, okay, previous year question mains. See the third question. Bring out the circumstance in 2005 which forced amendment to the Section 3D in Indian Patent Law 1970. Discuss how it has been utilized by the Supreme Court in its judgment in rejecting Novartis patent application for Glivec. Discuss briefly the pros and cons. Okay, now try to understand, it's a current affair. Now there was that question says that why in 2005 we have amended and introduced this section. What is the specialty of 2005? That was the year in which India had to comply with the TRIPS agreement. That is to shift from. So India was given a time period. Okay, I told you differential special treatment for developing country. So a time period was given for developing country like India to follow TRIPS agreement. So WTO came into existence in 1995. So So we'll just come back to this point, okay. So when TRIPS agreement came into force? Very simple, the day in which WTO came into existence, 1st January 1995. Now, so 1 year, 5 year and 11 year. So every developed country have to comply with the TRIPS agreement within 1 year, that is from 96 onwards. Developing countries were given, like India were given 5 year, 11 year was given to LDCs. But there was a extra clause was there for developing country. Extra clause was that if any developing country is presently not having this product patent, they will be given another extended 5 more years. So India was a country where we were not having product patent at that time, especially for this drug and other product. We were following process patent. Okay, so we got 10-year time to implement, to shift to process patent to product patent. And we already discussed yesterday, I told you that, okay, what is the problem when you shift from process patent to product patent? The price, there will be monopoly. Who will produce the product first? They will become the company. Nobody else can produce it for next 20 years. So in order, so we had a concern of this monopoly, so that in our patent laws were amended to means to avoid any misuse of these sections of this product patent. So one of that amendment was section 3D, where the purpose of the section 3D is to prevent evergreening of patent. So this Supreme Court case have shown that, okay, so do you think that section 3D is a violation of TRIPS agreement? No, section 3D is not at all a violation of TRIPS agreement. Okay, rather we are following it. Okay, so section 3D in India's IPR, this is a very, very, very important section, section 3D. Now what is section 3D is all about? It is about preventing evergreening of patent. We need to understand the concept, okay, preventing this section. So there are two important clauses, two important points under India's intellectual property rights. One is this section 3D. If anybody asks you, you need to tell them what is the specialty, why we have introduced this section 3D. We have introduced this section 3D in our Indian patent law to prevent evergreening of patent, evergreening of patent. And you know that what will happen if there is evergreening of patent, what will happen to especially a country like India. Okay, so regarding this patent provision, then one more thing we have done. One more thing we have done in as a part of this, you know, Doha Development Agenda, right? In Doha Development Agenda, there was a provision. Have you watched that video? I shared a video on Doha Development Agenda to your group. Anybody have seen it? Those who have not watched it, go home and watch it. Yesterday we could not able to explain it. Okay, it's there in your both any of your means. If you are in see anybody who is not there in our Telegram group, everybody is there now. You are seeing your timetable group there. I shared it in October batch also. I shared it with June batch also. Okay, please watch. There are two things I have shared it. Okay, one on Doha Development Agenda. Second is again on Agreement on Agriculture. Yesterday I was not well. I could not able to explain it fully. So that video is having. You just watch it again. It will get those who are still not clear about Agreement on Agriculture. If you want it, you can watch it. It's upon to you. Tomorrow I will delete it. It's you can watch. And today I will share one more thing, that is National Intellectual Property Rights Policy 2016. Okay, I think that is public only. Okay, anyway, so regarding this patent, you know that we are very much concerned about this patenting of drugs. I told you this is the most important concern for a country like India. So section 3D is ensuring evergreening of patent. Now as part of this Doha Development Agenda, I told you there is a provision called TRIPS versus public health. TRIPS versus public health. What is this TRIPS versus public health? If there is any emergency in our public health care or public health system due to any factors, For example, like if there is any emergency, that time we have, means a country like India have the right to violate TRIPS agreement. In the sense that, okay, so that only for, you can violate TRIPS agreement only in relation to any health emergency. Okay, so here even a patented drugs, so I told you, what do you mean by what is the specialty of a patented drugs? This drugs can be produced only by the company who have got the patent, but under certain conditions. When a country feels, especially one condition is that if there is any health emergency, or if the government feels that this company is charging exorbitant rate and it is not reasonable to the public, then on certain basis the government under this TRIPS versus public health provision have an option to use a tool what is called as compulsory licensing. It's very easy to understand what is called as compulsory licensing. You know what is licensing? We know what is licensing now. Licensing, who gives license? The owner, intellectual property owner, give the license to someone else. But here it is, the one more word is there. Compulsory means it is through force. Somebody is forcing you to give a license. Okay, normally if I am the intellectual property owner, I will give my right to someone else. I will give this licensing power to you and I will tell you, you give me this much of money. That's my own wish. But compulsory licensing is, it's been forced by the government. Forced by the government to the patent holder, mainly for what? For drug companies, okay? To compulsorily give your patent rights, to some other company. And other company will produce your same drug at a very, very, very lesser price. This is what is called as compulsory licensing. So this provision of compulsory licensing, we have in our Indian patent law. We have utilized it only once. We have utilized this compulsory licensing provision only once. Okay, and what we have done is, again to a cancer drug, we have given that compulsory license to some other Indian generic company called Natco Pharma. That drug name is this Nexavar. It's a company, the multinational company is Bayer. Nexavar drug, it's there in the material, was been given, the compulsory license was given to an Indian generic company called Natco Pharma, and they have sold that drug at a very lesser price. Now do you think that, so this multinational company or the country can take India to the WTO dispute settlement body? Will they take? Because no, compulsory licensing is under TRIPS agreement only, it is permitted under. So we have not, whether our section 3D, whether our compulsory licensing is not violating TRIPS agreement. If it is not violating TRIPS agreement, nobody will take you to WTO dispute settlement body. But majority of this pharma multinational companies is in US. So US is always pressurizing India to become liberal. To India, what it want? It want India to remove this section 3D from India's patent laws, and it want a guarantee from India that it will now in future it will not use compulsory licensing. And it was continuously pressurizing this new government. Earlier UPA government also, they was threatening. Now they can't, US can't take India to WTO. And you know US now. What US will do? It will threaten any country. And it was threatening. So it was continuously threatening India. Every year US will come with a report. Every year US will come with, the US government will come with a report called Special 301 report. And in this report, it will categorize certain countries as who are poor IPR regime country, and India belongs to that poor IPR regime country. And it always says that, okay, you are under prior, and India is been put under watch list, prior watch list category. India is under this special 301 report, India is under prior watch list category. And below that means, that is the last category, below that category means US will impose sanctions on India. But anyway, US will not, because of other reasons, because of this growing stature of China, US will not go for that extreme event. Okay, US at least need India to counter China. I'm not going to that part, it's IR part. But anyway, what I'm trying to say is that every year, so because of tremendous pressure from the US and other European countries, finally, this new government told that, okay, we are going to come with a new IPR policy. For the first time, Indian government in 2016, so due to the pressure from the multinational companies, finally we have come with a national IPR policy 2016. That's why in 2017 prelims UPSC asked that question. It was a current affair, that was a very prominent current affair. And US was expecting that everybody was very much, especially this this NGO and other activities, especially for healthcare infrastructure, was very much worried that whether Indian government will accept these US and other multinational companies' demands. But India, in the national IPR policy, stick to our earlier position that we didn't touch section 3D, we didn't touch this compulsory licensing provision, and what we have done is that rest we said that, okay, we will follow, we have a theme called Creative India, Innovative India. That is the theme of this national IPR policy. Means in India we are going to create, we are going to innovate. But rest of the things, okay, we have a big problem in our, because of this bureaucratic hurdles in relation to patent processing or trademark processing or giving them, because it took long time for a trademark, for in India to get a trademark or in India to get a patent. That what India have done is we have streamlined it. We are streamlining so that we will now, as per this national IPR policy, what we will do in India now, it will make it faster. We'll make it faster so that if a patent has been applied, the process will be faster and will be quickly given the patent and in relation to trademark also. But we stick to our, means we didn't touch this compulsory licensing provision and we didn't touch this section 3D also. While when the national IPR policy was out, India have reiterated it. Our national IPR policy was compliant with TRIPS agreement and also it was following the Doha development agenda. And it also made a single department, very important department under for an Indian economic student, that is Department of Industrial Policy and Promotion. This department was again, earlier we studied under, when we studied this department, under foreign investments we studied about this department. What is this? When FIPB was abolished. Now all the, so this DIPB will be, means this power was given to the respective ministry, but the respective ministry will consult with the DIPB. So that time it was in news. Okay. So in relation to national IPR policy, if there is any issue related with IPR policy, the nodal department or the nodal agency will be the DIPP. And this national IPR policy have come with 7 important objectives. Now your work in relation to this national IPR policy is that, I was expecting a question on national IPR policy for mains also, but this year, I told you, this year mains was purely a conventional area. So maybe you can expect this national IPR policy for your, that's UPSC, now you can prepare national IPR policy for your, since it was not asked this year, you can prepare it for your next mains. Okay, so national IPR policy, even though it had been given in the material, that's a brief thing. What you need to do is that it will be a revision for you. That's a video on national IPR policy. I will share it today. It's a 40-minute video on national IPR policy. What all things we have discussed here, we will be revising it, and also we will be analyzing this national IPR policy also. Please go and watch today itself. You watch that video, and I'll share that material also. So this national IPR policy 2016, national IPR policy 2016 is very important for you. So what we have done is that many of the things which we followed in our Indian patent law, we have continued it. Okay. Now we will solve that this national IPR policy question. First question, 2017 question. What is the first statement? This national intellectual property right policy, which year it has come? It's in 2016. It reiterates India's commitment to the Doha Development Agenda. What is there in Doha Development Agenda? TRIPS versus public health and the TRIPS agreement. Is it correct? It's a correct statement. Second statement is DIPP is the nodal agency for regulating intellectual property rights in India. So both the statements are correct. Now, from where UPSC have taken this statement? Now here comes the importance of PIB. See, just understand that this PIB articles are any important decision which, see, this is a major, PIB news is the major source of UPSC. Now what all PIB news are there, it will be copy pasted in almost all the national newspapers. Okay, so when we share PIB news in your Telegram group, read it religiously, because from there only, that's the original source, from there only UPSC will ask question, because UPSC have the tendency to ask, just cut, copy, paste the PIB articles like what I said it from the international official websites, because this is another source of UPSC where UPSC set question, UPSC question setters take statement from it. It's an authentic area, authentic place, Press Information Bureau. So the material which I had given with you, it's just a cut, copy, paste of PIB news which came on that day. If you notice one thing, okay, so if it was a PIB news, if you notice one thing, okay, take page number 20. Page number 20, have you seen that? Read the last para just before objective, read the last line. It reiterates India's commitment to the Doha Development Agenda and the TRIPS agreement. Is it cut, copy, paste? It's purely a PIB article. I have not done anything, I just made it bold, certain important words, that's it, that's my job I have done. Then, see the last para. These objectives are sought to be achieved through detailed action points. DIPB, which shall be the nodal department to coordinate, guide and oversee, implement and future development of the IPRs in India. Okay. So the source for this question was this PIB article only. So it's not for this in many questions, in many areas, especially for the many new schemes or policies which the government will announce. First it will be released in the PIB. Then there will be analysis. Analysis is important for your mains. But from your prelims, the authentic source is the PIB article. So not for this, but in any future articles which we share, which will be sharing it in the Telegram groups, you read it. Okay, just showing you that in many, there are many things which will be conveying it. You have an idea and follow it and prepare accordingly, so that nobody can stop you from writing mains in the coming year. Now, so please go as part of revision after reading this material, when you get time, revise this national IPR policy. So section 3D and compulsory licensing as it's very important. Now if you take your material, okay, so material is, it's page, how many pages are there? How many pages are there? 22, 23. Huh? 22 or 23? 23, you will leave that. It's only one question is there. Now try to understand why this is a comprehensive material. One is it's important for prelims. Second is It is important for your mains also. If you see the GS3 syllabus, 13th module, you have a topic called issues relating to intellectual property rights. So the major two issues presently relating to intellectual property right is section 3D and CL. Okay. Now the new issue is India's national IPR policy. Now anything else, if copyright is in news, if GI is in news, if trademark is in news, or patent is in news, note down, because these are all your part of your syllabus, which is mentioned in the mains and it's already been asked in prelims also. Then there are other intellectual property which is not important for you, like industrial design. Okay, industrial design, then this layout of integrated circuits, all are what will come under the second part, classification under industrial property. It's not that important, but they all are part of intellectual property. It has been given in your material, just go and read it. Okay. Now try to understand that. See, WTO, while studying WTO, I told you, TRIPS is only an agreement. See, WTO is a trade body. Under the trade body, under WTO, you have area, means WTO covers areas in relation to trade in goods, trade in services, issues related to intellectual property rights, and also investment. Okay. Now, so TRIPS is not an organization, rather TRIPS is an agreement, multilateral agreement or a plurilateral agreement. TRIPS is what is the specialty of multilateral agreement? Everyone have to be a member and everybody is binding. TRIPS agreement is binding on all the members. Okay, so one more information regarding this intellectual property is that there is an international organization exclusively to deal with intellectual property issues, like trade organization. Trade is, it's covering vast area, but in relation to deal issues associated with intellectual property, there is an exclusive organization, what is called as WIPO, World Intellectual Property Organization. WIPO, World Intellectual Property Organization. World Intellectual Property Organization. Now, see, in many of from the UPSC point of view, all the organizations' headquarters are very important. See, members are not important because every year new members will be added. But if any new member has been added and if it is coming in news, just note down. So, headquarters of every organizations are very important because that's a favorite area of UPSC in prelims. So, the headquarters of WIPO and WTO are same. So, you can easily remember. If you know the headquarters of WTO, that is the headquarters of WIPO also. So, what is the headquarters of WTO? Geneva. So, WIPO's headquarters is also Geneva. Okay. And another important thing is that you need to know is that whether WTO, is WTO a specialized agency of the UN? No. What about IMF? What about World Bank? And WIPO is a specialized agency of UN. Note down. It's a specialized agency of, these are the two keywords. Rest of the thing, obviously, as an intellectual property organization, global intellectual property organization, you know the functions of this organization. What is that? To protect and promote intellectual property regimes. What TRIPS agreement is doing, so it will also support the TRIPS agreement also. But rather TRIPS agreement is under WTO, but it will support it. Because TRIPS is also dealing with intellectual property. This is an organization which want to protect and promote intellectual property. So that information is more than sufficient for you. And if WIPO is in news, just note down it. Okay. Again, second thing regarding this international organization is that, okay, now this UN is back. United Nations have become a favorite area of UPSC. It is showing in the 2016 mains and also in the 2017 mains. In the last 2 years, So it shows that in your coming prelims. So UPSC, as it means that there are some new idiot have come to set your questions. Okay, that's why it's showing it. Okay, so his question is coming. So this person will be there in your prelims also, or that the chances that he may have influenced. So what I am trying is that UN organizations are very important now, because now it is showing. Okay, yesterday this GS2 question paper, there was a question on UN organization. In 2016 also there was a question on UN organization. Normally we don't give so much of importance. So just will anyway under IR it will be discussed. Okay, but just keep a note of it, and when you have time, please go through the 2017 question paper. 2017 mains question paper, prelims question paper is assigned to your 2018 prelims questions. It shows where UPSC is presently inclined to, what type of questions you can expect in your coming prelims and mains, and that makes your preparation much more effective. So without seeing the latest pattern of UPSC question, don't prepare for your preparation. It will not be, so that's why I'm telling that. So by seeing the 2000 mains question paper, I got an indication that there is a high possibility that, see, last 2 year current affair is, last 2-3 year current affair is at the peak in relation to prelims. Now everybody will stop doing conventional, because anybody will open Lakshmikant, then people will say that, why you are studying Lakshmikant, no question is coming from Lakshmikant. Then next that year 20 questions from Lakshmikant will come. So what I am trying to say is that, okay, you make sure that your preparation is balanced. First and most important thing is that be good in all the conventional areas, conventional subjects, and then be too good in current affair also. Nobody can stop you in writing means. Then what you basically can do? There is no other option. You prepare. Okay, now there is a question on Vipo Solid. Question number 4. 4 statement question, easy question, anybody can answer. First statement correct? So you can eliminate. Even if you don't know first statement, you can answer it. What about second statement? Eliminate. What is the answer? No need to read third statement. No need to read fourth statement. This is UPSC for you. See, not our test series question is like this. It's UPSC is like this only. So, follow the first model test 1 discussion. What I've told you in the test 1 discussion, I had given you a very important vital techniques. Follow it in all your coming tests. Okay, that will make a very big difference. Anybody who missed MT2 who was sitting here? See, don't miss any test series, otherwise it will means you qualifying prelims becomes very difficult. How much you study, don't wait for your preparation. Without preparation, come and write prelims. That test series, prelims test series is for those who are not preparing. Just come and write it and use all these methods. Okay. Anyway, so just follow the pattern. Okay. Now, for you, I am telling you, you can expect a question from IPR for your coming prelims from external sector. From external sector, UPSC will minimum ask 5 questions. Minimum will ask 5 questions. Now, one more topic is there called trade agreement. With trade agreement, all the conventional area of external sector is over. If any conventional question will come from external sector, it will be from this area. Now, what is left? Current affair. Now, regarding current affair, if you are strong in conventional area, current affair will become very easy for you. We can easily predict current affair from external sector. It's very easy to predict in relation to external sector. But to understand the current affair, your base need to be very strong. That 5 questions will make a decider in external sector. Okay, so revise. Your economic test is also come. Every student should write that. If you're not writing the economic test, then I'll show you. Okay, so okay, so my entire energy is been putting on this only. Every trick, every concept, everything like a school spoon feeding, I am doing it, and then you are not coming and writing the test. Then we'll see it. Okay. Anyway, so the 6th test is on economy. So basically, it will be a current affair sum and plus external sector sum question. We'll inform you the syllabus. So please go home today itself, revise it, And yesterday material who have not revised, revise it and watch those video, and the third video which I will be posting it today. Okay, along with that video I will be sending a material also on national IPR policy. Okay, see, UPSC have asked a question from national IPR policy 2016, but it doesn't mean that UPSC will not ask this question again. If IPR policy 2016 is again in news, they will ask a different question from that topic. Okay, or you expect national IPR policy 2016 for your coming mains. Coming mains means next year when you write your mains. Okay, so go home, revise it, these things. Okay, if you have noted down what all things I have discussed, any question, conceptual related question on IPR, any conceptual related question on IPR, you can solve it provided your concept is clear, provided you are applying the techniques which I taught you. Okay, so don't worry, but if it is a new current affair, we'll see it. I'll consolidate all the current affair and we'll let you know what are the important current affair from January 2017 to March 2018. Okay, so we'll come with a, I'll let you know what are the important current affair. Okay, so study well, we'll see you in the next week. Thank you.